Good morning to everyone in and around this courtroom. Madam Magistrate, would you please call the case?
Good morning, Your Honours. This is case IT 0992T, the prosecutor versus Ratko Mladić.
Thank you, Madam Magistrate. I see that the prosecution is represented by Mr. Groom and Mr. McCloskey. I see that Mr. Mladić is represented today by Mr. Mladić, who is a member of the defense team, and the chamber received the consent of Mr. Mladić that Mr. Mladić would represent him today in the absence of counsel. The chamber will now deliver its decision on the defense's request for acquittal pursuant to Rule 98 bis. The chamber heard oral submissions from the defense on the 17th of March 2014 and in response from the prosecution on the 18th of March. On the 19th of March, both parties made further submissions. In reaching its decision, the chamber has considered all submissions of the defense and the prosecution, as well as all evidence admitted by the time of hearing the submissions. The chamber will first give a brief summary of those submissions. Thereafter, it will address those submissions, give an overview of the indictment, and then address the evidence related to all counts of the indictment. The defense made 4 submissions under Rule 98 bis. First, the defense argues that the word count in the text of Rule 98 bis has been restrictively interpreted by trial chambers to mean that judgments for acquittals can only be entered in respect of entire counts and not individual charges or incidents. The defense submits that the precise meaning of the wording of Rule 98 bis should be determined with recourse to the intention of the drafters and the object and purpose of the rule. According to the defense, the object and purpose of Rule 98 bis is to streamline the case by removing allegations that cannot be sustained, ensuring that the trial is expedited and that the defense's resources are not laid to waste. Secondly, the defense requests that the charges concerning the Jadar River incident, which is scheduled incident E11, the charges concerning the Sirokacha shelling incident of the 28th of May 1992, which is part of scheduled incident G1, and all the charges relating to destruction of cultural monuments and sacred sites set out in Schedule D be dismissed. Thirdly, the defense submits that the prosecution has not proffered any evidence capable of sustaining a conviction under Article 7(3) of the statute on crimes perpetrated by third-party or non-VRS actors. In advancing this proposition, the defense asserts that the prosecution has failed to identify the subordinates over whom it alleges that the accused exercised effective de jure or de facto control. In addition, the defense contends that there is evidence which supports the claim that the accused did not have effective control over armed groups other than the Bosnian Serb army, hereinafter VRS, in particular over the Bosnian Serb Ministry of Interior, hereinafter MUP, forces, Aaken's Tigers and the Scorpions. Fourthly, The defense makes a number of submissions with respect to genocide as charged under counts 1 and 2, characterizing the prosecution's evidentiary basis as deficient in meeting the reduced burden of proof set by Rule 98 bis. In respect of count 1, the defense argues that in the case concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide, the International Court of Justice, hereinafter referred to as ICJ, decided to dismiss allegations of the crime of genocide in the municipalities on the ground that there existed insufficient evidence of the specific intent to destroy a protected group. The defense also points to the judgments in the cases of Stakic, Sikirica, Krajisnik and Brđanin, which concluded similarly. Moreover, the defense argues that even though the Chamber has received evidence of criminal acts directed against Bosnian Muslims and Bosnian Croats in the municipalities, the evidence on these crimes does not establish that they were committed with genocidal intent. As regards count 2, the defense argues that according to the testimony of General Milovanovic pertaining to Military Directive 7.1, the accused left out two crucial portions of Directive 7 when issuing Directive 7.1. The first of these two portions was Karadzic's instruction that complete physical separation of Srebrenica from Šepa should be carried out as soon as possible. The second related to the creation of an unbearable situation of total insecurity with no hope of further survival or life for the inhabitants of Srebrenica and Šepa. The defense submits that the accused, by leaving out these two instructions, has shown that he did not share the common purpose to commit genocide in Srebrenica. The Chamber now moves to the prosecution's submissions. Responding to the defense's first three submissions, the prosecution argues that the defense has provided no sound reason as to why the Chamber should depart from the well-established practice of this tribunal and look within each individual count and examine whether the accused may be acquitted of a portion thereof. Moreover, the prosecution submits that there is sufficient evidence to maintain the charges specifically challenged by the defense. The prosecution sets out the evidence concerning each of the counts in the indictment, especially in respect of counts 1 and 2. As regards count 1, the prosecution submits that there is evidence indicating that in 1992, Bosnian Muslim and Bosnian Croat communities were targeted for destruction, and that those that survived the ensuing destruction were forcibly displaced. According to the prosecution, the combination of physically destructive acts and other acts targeting the foundation of the two protected communities, such as displacements and the destruction of property and cultural and religious sites, effectively led to their physical demise and their inability to reconstitute themselves. The prosecution submits, moreover, that the fact that the ICJ did not declare that in 1992 genocide had occurred in Bosnia and Herzegovina is not relevant to the present proceedings, as the ICJ made that determination on the basis of a different legal standard and a different body of evidence. Furthermore, the prosecution argues that in all prior tribunal cases at the Rule 98 bis stage, the genocide count for the municipalities has been upheld, whether by trial chambers or by the appeals chamber following an appeal. With regard to count 2, the prosecution submits that Directive 7 and Directive 7.1 form an indivisible whole, since Directive 7.1 expressly refers to Directive 7. The wording of the latter document therefore remains valid and important. The Chamber will now set out the law applicable at this stage of the proceedings. Rule 98 bis of the Tribunal's Rules of Procedure and Evidence provides as follows. I quote, "At the close of the prosecutor's case, the trial chamber shall, by oral decision and after hearing the oral submissions of the parties, enter a judgment of acquittal on any count if there is no evidence capable of supporting a conviction." End of quote. Under the case law of the tribunal, the chamber must examine whether there is evidence upon which a reasonable trier of fact could be satisfied beyond a reasonable doubt of the guilt of the accused. Thus, if a reasonable chamber could be satisfied beyond a reasonable doubt of the guilt of an accused on the basis of the evidence adduced in relation to a count, then the count must stand. There must be sufficient evidence for each element of the alleged crimes and for one of the modes of liability contained in the indictment. The test would not be satisfied if there was no evidence. If the prosecution has presented evidence, that evidence is entitled to credence unless incapable of belief. At this stage, the evidence should be taken at its highest for the prosecution. The chamber therefore will not concern itself with issues of credibility or reliability unless a witness is so lacking in credibility and reliability that no reasonable chamber could find him or her credible or reliable. As a preliminary remark, before addressing the submissions in substance, the chamber notes one matter. During its Rule 98 bis submissions, the defense objected to how the indictment was pled, suggesting that the charges lack specificity. In particular, the defense invited the chamber to consider the, and I quote again, far-reaching consequences of including this many actors as sharing in the common purpose in light of the lack of specificity in the indictment. End of quote. According to the rules, motions challenging the indictment are to be filed prior to the start of a case. On the 13th of October 2011, the Chamber decided upon such a motion and dismissed alleged indictment defects, including those raised now again by the defense. The Chamber will not revisit the issue. The Chamber will now address the parties' submissions. In relation to the defense's first argument, the Chamber considers that Rule 98 bis, as a procedural rule, is a corollary of the right of an accused to be presumed innocent until proven guilty. There are various procedural avenues which give effect to this right, and they are not necessarily limited to the stage of the end of the prosecution's case. The rules amendment in 2004, adjusting the scope of Rule 98 bis decisions, was intended to streamline the proceedings in the interests of judicial economy. The amendment changed the procedure from a written to an oral one and shifted the determination to be made to the counts rather than to individual charges in an indictment. The rules amendment did not affect an accused's right to be presumed innocent until proven guilty. Effect will ultimately be given to this right in the final judgment. The Mladić trial chamber, in its Rule 98 bis decision issued on the 20th of February 2014, presented an extensive overview of the practice in this tribunal in relation to the count-based approach of Rule 98 bis. The Chamber further notes that a failure of the prosecution to adduce any evidence or insufficient evidence on individual charges has an effect on the proceedings that will follow. For the purpose of preparing and presenting its evidence, the defense will in effect be left with no case to answer in relation to those individual charges. The defense is not forced to spend resources to challenge charges which it believes have not been supported by evidence. The defense is not forced to present any evidence for that matter. The prosecution has to establish beyond a reasonable doubt that the charges are proven. If, according to the defense, the evidence does not prove the charges, it may decide to refrain from presenting evidence thereon. This may especially be the case in relation to charges where the defense believes that the prosecution has not even met the lower threshold applicable at this stage of the proceedings. For the foregoing reasons, the Chamber rejects the defense's first argument. In its second argument, the defense challenges a number of specific incidents: the Jadar River killings, the shelling of Sriracha on the 28th of May 1992, and the incidents listed in Schedule D of the indictment in relation to destruction of religious sites. The Jadar River killings incident is one out of 20 scheduled killing incidents in relation to Srebrenica alone. The Sriracha shelling is not even specifically mentioned in Schedule G to the indictment, but forms part of Scheduled Incident G1, which charges shelling of the city of Sarajevo as of the 28th of May 1992. The destructions of religious sites are part of one of 7 charged underlying acts of persecution for the municipality's part of the case. The other part of this underlying act concerns the destruction of public and private property. Considering these very narrow challenges, and in light of the Chamber's analysis of Rule 98 bis and the tribunal practice developed as set out earlier, the Chamber will not further consider these incidents in this decision. The defense further generally challenged the mode of liability under Article 7(3) of the statute, on the basis that the prosecution has failed to establish that non-VRS persons or groups allegedly committing crimes were under the effective de jure or de facto control of the accused. In addition, the defense asserts that there is no evidence to suggest that the accused issued any criminal orders to persons who are alleged to have been perpetrators of crimes, and therefore liability under the ordering limb of Article 7.1 cannot be sustained for charges in the indictment. The Chamber refers to its position in relation to challenges to portions of account set out earlier. In similar vein, considering that various modes of liability are charged in respect of all counts, it is sufficient that there is evidence capable of supporting a conviction on the basis of one of the modes of liability. The defense challenges in this respect are narrow, given that they pertain to one element of the alleged superior responsibility of Mladić, the de jure or de facto control under Article 7.3 and ordering under Article 7.1, and in relation to a small number of alleged perpetrator groups. For the foregoing reasons, the Chamber rejects the defense's third argument. The Chamber further considers that the defense's challenges of the specific crimes do not extend to a challenge of the general elements and jurisdictional requirements that must be proven under Articles 3 and 5 of the Statute of the Tribunal. Notwithstanding the above, the Chamber considers that there is a duty under Rule 98 bis to assess whether there is evidence capable of supporting a conviction on every count of the indictment, irrespective of whether the defense explicitly challenged all counts. For a better understanding, the Chamber will first provide a summary of relevant parts of the indictment. The indictment covers 11 counts of crimes allegedly committed between March 1992 and the 30th of November 1995. The areas covered by the indictment include Sarajevo, Srebrenica, Gorazde, and the following municipalities in Bosnia and Herzegovina, which are dealt with together in the indictment: Banja Luka, Bijeljina, Foča, Ilija, Kalinovic, Cluj, Kotovaras, Novigrad, Pale, Prijedor, Rokatica, Sanski Most, Sokolac, Trnovo, and Vlasenica. Hereinafter, I will refer to the part of the indictment covering those 15 municipalities as the municipalities. According to the indictment, the accused held various positions in the Yugoslav People's Army, hereinafter referred to as JNA, and later in the VRS, and was the commander of the main staff of the VRS as of the 12th of May 1992. The first two counts charge genocide. The third count charges persecution as a crime against humanity. The fourth and fifth counts respectively charge extermination and murder as crimes against humanity. The sixth count charges murder as a violation of the laws or customs of war as recognized by Common Article 3(1) small a of the Geneva Conventions of 1949. The seventh and eighth counts respectively charge deportation and the inhumane act of forcible transfer as crimes against humanity. The ninth and the 10th counts respectively charge terror and unlawful attacks on civilians as violations of the laws or customs of war. The final count charges taking of hostages as a violation of the laws or customs of war. The indictment alleges that the accused and others participated in an overarching joint criminal enterprise, hereinafter referred to as JCE, the objective of which was the permanent removal of Bosnian Muslims and Bosnian Croats from Bosnian Serb-claimed territory in Bosnia and Herzegovina. This objective was allegedly carried out by the commission of crimes charged in counts 1 and 3 to 8. Alternatively, this objective was carried out by the commission of crimes charged in counts 7 and 8, while the accused willingly took the risk of the commission of crimes charged in counts 1 to 6 as a foreseeable consequence of the implementation of the objective. According to the indictment, the accused's participation in the JCE included commanding and controlling the VRS and other elements of the Serb forces and encouraging the commission of crimes by members thereof. It also included participating in the development of Bosnian Serb governmental policies and disseminating propaganda intended to advance the objective of the JCE, failing to take adequate measures to protect prisoners of war and detainees under his effective control, as well as directing the restriction of humanitarian aid to non-Bosnian Serb enclaves. The indictment further alleges that the accused and others participated in 3 additional JCEs. The objective of the second JCE was to spread terror among the civilian population of Sarajevo through a campaign of sniping and shelling consisting of crimes charged in counts 5, 6, 9 and 10. The objective of the third JCE was to eliminate the Bosnian Muslims in Srebrenica through crimes charged in counts 2 to 8. The objective of the fourth JCE was to take United Nations personnel as hostages through the crime charged in count 11. The accused's participation in these 3 additional JCEs included various forms of participation in the overarching JCE. The indictment further charges the accused with criminal responsibility for having planned, instigated, ordered, and/or aided and abetted the crimes, as well as with criminal responsibility as his superior. The Chamber will now address whether each count of the indictment stands. In its legal characterizations, the Chamber adopts and applies the Tribunal's consistent case law with respect to the definition of the elements of the crimes and modes of liability charged in this case. In this decision, the Chamber will address the law more specifically only when this is required to explain the Chamber's findings. The volume of evidence before the Chamber and the character of the Rule 98 bis proceedings do not allow for a comprehensive discussion of the evidence in this decision. The Chamber has, however, considered the evidence in its entirety. The specific evidence that the Chamber will refer to in this decision is therefore a focused selection of what the Chamber has considered to be relevant for the purposes of this decision. In relation to the crimes charged, the Chamber verified whether the evidence addresses all the elements of each of the crimes. Similarly, it verified whether the evidence addresses all the requirements for criminal responsibility as charged against the accused. Finally, in relation to each crime charged, the Chamber verified whether the evidence, taken at its highest for the prosecution, could lead a reasonable trier of fact to conclude, beyond a reasonable doubt, both that the crime has been committed and that the accused bears criminal responsibility for it. Turning to the counts, in relation to counts 1 to 3, 5 and 6, there is evidence of crimes taking place during the enlightenment period in the municipalities and Srebrenica. The Chamber will start with murders in the municipalities part of the case and will focus on a few incidents in order to determine whether the counts stand. In relation to scheduled incident B16.2, the Chamber heard from witness RM066 that on 30 September 1992, 4 Serb police officers sent by the Chief of the Public Security Service, hereinafter SJB, in Mladić arrived at the Sušica camp. During the night, the Serb police officers called out 3 groups of detainees, each consisting of 30 or 40 persons, loaded them into a truck, transported them from the camp. The witness later learned from Ilija Janković, a police officer from the SJB Mladić, that the majority of these detainees, mainly Muslims from Mladić and surrounding villages, had been killed. The witness testified that the camp was a joint operation between the VRS and the Bosnian Serb MUP in Mladić municipality. In relation to scheduled incident B5.1, the Chamber received evidence that in July 1992, the KP Dom Foča detention warden Mladić reported that 469 prisoners had been brought to the KP Dom detention center since the start of the war, 459 of whom were Bosnian Muslims. This is contained in Exhibit P4019. Witnesses RM063 and RM046, who were detained at the KP Dom detention center from April 1992 for a period of 6 months and more than a year respectively, testified that every night during their detention, a number of detainees were taken out for beatings. Witness RM63 testified that the beatings were carried out by a policeman called Dragoljub Obrenović and a number of KP Dom guards. According to witness RM63, detainees were very often taken to solitary cells from which moans, screams, thuds and shots could be heard. During a weekend in August 1992, witness RM63 saw approximately 200 detainees taken away in groups from the KP Dom. These detainees never returned. In relation to scheduled incident B13.1, witness Safet Taci, who was detained in room 2 of Keratam detention camp, testified that one day he saw a table with a machine gun and a portable spotlight being put up and directed at the door of room 3, a small room where 180 to 200 detainees were squeezed in. Around midnight, he heard machine gun fire after the door of room 3 had been opened and people started to stream out. The next day, the witness was ordered by a soldier to load the bodies inside and in front of the door of room 3 onto a truck. The chamber notes that according to one adjudicated fact, the machine gun outside room 3 had been placed there by Bosnian Serb army personnel on the 20th or the 21st of July 1992. In relation to scheduled incident B8.1, witness RM018 stated that on the 31st of May 1992, soldiers wearing JNA uniforms escorted him and around 70 other Muslim men from Kastovici and Vojici to a room in an elementary school in Velagici. At 11:30 p.m., soldiers cursed and beat the men and ordered them to form a line and face 2 armed soldiers. Soon after, those soldiers opened fire at them. The witness was able to hide under the bodies. The witness heard the soldiers discussing going to Lanište, where the Knin Corps was stationed, to get a loader and a truck to dispose of the bodies in the forest. In relation to scheduled incident A3.3, witness Djevat Javerigic stated that on the 10th of July 1982 at about 5:30 a.m. he woke up to the sound of automatic gunfire. From his house, he saw a convoy of 50 to 60 men in civilian clothes being led to Cluj by 8 or 9 Serb soldiers wearing JNA uniforms. The witness saw Serb soldiers entering houses, removing men and beating them. From approximately 10 a.m., groups of Serb soldiers wearing JNA and camouflage uniforms escorted groups of 7 or 8 Muslim men to a stable from where he heard gunfire. At approximately 6 p.m., the witness saw a yellow excavator and a lorry arrive at the stable and several unidentified Serb soldiers loading bodies from the stable onto the excavator. During this process, one of the soldiers said, and I quote, "That is the way of the true Serb." End of quote. The chamber heard evidence indicating that the attack had been planned and carried out by troops belonging to the VRS. In relation to all of these incidents, the chamber also received forensic material in support of the witnesses' evidence. The chamber will at a later stage make a determination whether the evidence is sufficient for certain counts to stand. The chamber will now turn to Srebrenica. The chamber heard the evidence of witness Dražen Ardemović, who testified that on the morning of the 16th of July 1995, he and 7 other members of the VRS 10th Sabotage Detachment were ordered by their group commander, Brano Gojkovic, to go to the Zvornik Brigade headquarters. From there, they were escorted by a VRS lieutenant colonel and 2 members of the Drina Corps military police to Branjevo military farm. Upon arrival at the farm, Adamovich overheard Gojkovic talking with the lieutenant colonel about buses arriving, and then Gojkovic told the witness and the other members of his unit that buses carrying civilians from Srebrenica would arrive, and they were to execute these people. Buses began arriving carrying Bosnian Muslim males aged between 17 and 65 and dressed in civilian clothing, and each bus had 2 armed Drina Corps military police escorts on board. The Bosnian Muslims from the first bus were blindfolded and had their hands tied together. The detainees were led from the buses to the execution site, where Adamovich and the other VRS soldiers were ordered by Gojkovic to open fire on them. Adamovich also testified that Gojkovic had ordered the bus drivers to kill at least 1 prisoner each, so that they would not later testify about what had happened. Later that day, as the last bus with Bosnian Muslims detainees arrived, a group of 10 VRS soldiers from Bratunac joined the witnesses' unit at the execution site. These soldiers beat and cursed the detainees, forcing them to kneel and pray, and I quote, "in the Muslim manner," end of quote. The VRS lieutenant colonel, who had earlier escorted the witness and member of his unit to the execution site, arrived at the end of the executions and discussed the burial of the victims in the field. Adamovich testified that he and other VRS soldiers participated in the execution of between 1,000 to 1,200 Bosnian Muslim males, dressed in civilian clothes, who had been brought to the execution site by between 15 and 20 buses that day. The chamber also heard evidence from witnesses RM 346 and RM 255, who testified about surviving the Branjevo farm executions. Both witnesses gave evidence that after being captured and detained by soldiers, they and other Bosnian Muslim detainees, some of whom were blindfolded with their hands tied behind their backs, were transported by bus to a field on the 16th of July 1995. Witness RM 346 testified that upon arrival, Serb soldiers began cursing the detainees, saying things like, and I quote, "Alia does not want you. Step out." End of quote. As the soldiers took the detainees off the buses in groups of 10. Witness RM 255 gave evidence that one of the soldiers asked if he wanted to declare himself as a Serb and then be released. In response to this, 2 of the detainees then said they were Serbian, but were not separated from the line. The detainees were led to an area where they were lined up between corpses that were already on the ground. They were ordered to turn their backs and to lie down, and then a group of 10 soldiers began shooting the detainees. Having survived the executions, witnesses RM 255 and RM 346 lay motionless among the corpses, listening to the process repeat itself throughout the day. The soldiers returning multiple times with groups of detainees, ordering the detainees to line up, shooting them, asking if anyone was still alive, and then killing anyone that responded. Witness RM 255 also gave evidence that on 2 occasions he heard that the soldiers were making statements about them committing genocide. Once while he was being led to the execution site, and another time after his escape while he was hiding nearby. The Chamber will at a later stage make a determination whether the evidence is sufficient for certain counts to stand. The Chamber will now set out some evidence on rapes and cruel and inhumane treatment for the municipality's part of the case. The Chamber also heard evidence in relation to a large number of rapes committed at various locations in Foča municipality. For the purposes of this decision, the Chamber will focus on the evidence it heard regarding Karaman's house, as set out in Schedule C6.2 of the indictment. Witnesses RM070 and RM048 testified that around 3 August 1992, they and other girls were taken by one of Pero Eles's soldiers and the soldiers of Dragan Kunarac, also known as Jaga, in Miljevina, Foča municipality. Witness RM70 testified that the youngest girl at Karaman's house was 12 years old. During the evenings, soldiers from Pero Eles's group raped one or more of the girls, and the soldiers would regularly beat the girls when they refused to follow orders. Witness RM70 testified that Pero Eles raped all of the girls once or twice. Witness RM48 testified that she learned that Eles was the commander of a group of soldiers under the command of Marko Kovac, about whom the Chamber heard evidence that he was the commander of the VRS Brigade from May 1992 until the end of 1994. Around mid-August 1992, witness RM48 was taken from Karaman's house to the house of a Serb soldier, where she was held and raped until she was released in July 1993. During this time, the soldier took the witness to a celebration, where Mladić approached them, asking the soldier whether the witness was his, I quote, Herzegovinian girl, end of quote. Mladić then turned to the witness directly and asked her whether it was, and I again quote, better than in Alia's state, end of quote. The witness testified that this made her believe that Mladić knew about girls that were kept as sexual slaves. According to witness RM48, there were no Muslim women or girls living freely in Foča at the time. The Chamber notes that one of Mladić's notebooks, Exhibit P359, records the names of 2 young women the Bosnian Herzegovina officials were looking for, and about whom witnesses have testified they were held in Foča as sexual slaves. The Chamber heard a large amount of evidence regarding the cruel and inhumane treatment of persons detained in camps in the municipalities. For the purposes of this decision, it will only focus on the Keraterm and Omaska camps in Prijedor municipality, mentioned in Schedules C15.2 and C15.3. 15.3 of the indictment, and Mladić camp and Banja Luka municipality referred to in Schedule C1.2. In relation to Kuraterm camp, Safet Tachi testified regarding his detention in room 2, which was approximately 10 by 12 meters, very hot, unhygienic, and filled with a large number of Croats and Muslims, many of them severely beaten. The witness testified that on one occasion, a man by the name of Ducha entered room 2, called on 2 detainees who were brothers and forced them to beat each other severely. According to the adjudicated facts, the Kuraterm camp held up to 1,500 prisoners, crowded into a number of large, unlit rooms or halls, which got intensely hot in the summer as there were no windows or ventilation. Prisoners were kept locked in these rooms for days, crowded together. The detainees were allowed to go to the toilet only once a day. Infestations of lice appeared at the camp, and dysentery was rife. There was no medical care. Detainees suffered from malnutrition and starvation and were beaten on arrival. In relation to the Yamaska camp, witness Nusret Sivat testified he was taken to Yamaska camp on the 20th of June 1992. Upon his arrival, he and other prisoners were beaten severely by members of an intervention platoon, including Mrđa and Zoran Babić. On one occasion, all the detainees in the camp were beaten from the early hours of the morning until late afternoon. The shift on duty, led by Mladić, also known as Kurkan, set up a gauntlet of guards, assisted by guards from other shifts. The witness saw people screaming and falling down everywhere as the guards beat them with baseball bats and metal chains with balls attached to them. One guard struck the witness on his head, using a metal chain and ball, after which he lost consciousness. According to the adjudicated facts, sometimes 200 persons were held at the Yamaska camp in a room of 40 square meters, and 300 prisoners were confined in one small room. Some prisoners spent the time crowded together in the lavatories. In the lavatories, prisoners were packed one on top of the other, and they often had to lie on excrements. Many of the prisoners confined in the White House on the Yamaska compound did not receive food during their time there. Some prisoners lost 20 to 30 kilograms during their time at Yamaska, others considerably more. Drinking water at Yamaska was often denied to the prisoners for long periods, and the water given to the detainees was not fit for human consumption. Prisoners had to wait hours before being allowed to use the lavatories, and sometimes risked being beaten if they asked to use them. There were no effective washing facilities. Skin diseases were prevalent, as were acute cases of diarrhea and dysentery. The chamber also received a large number of detailed reports that were sent to the VOS officials regarding the inhumane treatment in the camps. From as early as the 22nd of June 1992, the operational team in charge of interrogating the detainees in the Mladić camp sent daily reports to the 1st Krajina Corps Commander Mladić regarding the treatment of prisoners in the Mladić camp in Banja Luka. On the 1st of July, it was reported that, and I quote, more than 95% of the prisoners are Muslims. End of quote. The operational team urged Mladić to remind the military police commander at the camp that it, again I quote, is not a torture house. End of quote. That prisoners were, and I quote again, maltreated, beaten, and humiliated to the extreme. End of quote. That the policemen at the camp beat the prisoners as they pleased, but that it was difficult to eradicate this behavior, as the security commander of the camp often said in front of the soldiers that the prisoners, and I quote again, should all be killed. End of quote. On the 22nd of July of 1992, a daily report mentioned that it was the first time that the operational team had witnessed that a group of detainees had been brought to the camp, and I quote again, intact, i.e., there are no traces of violence. End of quote. After we've taken a break, the chamber will start to assess whether counts 1 to 3, 5 and 6 stand as far as the crime-based evidence is concerned. We first take a break and we'll resume at 11 o'clock.
All rise, faithfully.